we're still missing a couple of folks on the road, so hopefully they'll join us in due course. I'm going to turn it over for some opening comments to Tommy Honest, who's our editor-in-chief of the Missouri Law Review. Tommy?
On behalf of the Missouri Law Review, we welcome you all to Missouri for our annual symposium. This year, one of the topics of federalism and international law. A little could I expect 2.5 years ago, actually moving from Estonia to the United States, more specifically to mid-Missouri, London, Missouri, that this school will have a symposium devoted to international law. At that time, major interest to myself as well. It's not that surprising though. Even during our orientation, we were let know in very clear words that the world has become more and more international and globalization is taking place. And even a lawyer in mid-Missouri cannot escape international aspects in practicing. Now, for this symposium to take place, there are a few people the Missouri Law Review wants to specifically thank. And first of all, we thank Professor McGinnis for inviting you all here, and who came up with the idea without any provoking from the Law Review side at all. And who has been great in helping the Law Review run a few things, although I must say she has been running things in the Law Review this year. Only positive words about that. I'd also like to thank the University of Missouri School of Law, who has started the symposium edition and has enabled the Law Review to obtain more exposure via the symposia. I'd also like to thank all the Law Review members and the University of Missouri School of Law staff members, especially Robin on his right behind that door there. We are not going to disappear from around you for this symposium. To the contrary, we want to make your stay here as comfortable as possible. And if you have any questions regarding the symposium, or also during about the aftermath, meaning the publication process, do not hesitate to turn to any of the Law Review members, including myself. There are two Law Review members whom I also would like to specifically mention. They aren't here, they're probably organizing something. They're Will Markinson and Charles Adamson, who have been taking care of most of the logistics. Finally, about the publication process, I hope that we will be acting in the same way as we tried to act during the conference. We will be as much help for you, but we will not by any means start harassing you with our publication needs. So for the introductory remarks, let me turn over the floor to Dean Lawrence Tesson.
I am Larry Desson, the Dean here at the University of Missouri Law School, and it's my great privilege and pleasure to welcome you here to a much anticipated Missouri Law Review Symposium, Return to Missouri versus Holland. And there are obvious reasons why this is significant to us. This symposium, as have symposia in the past, brings just a wealth of the leading legal thinkers in the nation to deal with these issues that become increasingly important to us, both here in the United States, in our state governments, and around the world. This symposium has been the dream and the hard and creative work for Professor Peggy McGinnis for the last year. About this time last spring, he proposed this topic and has been working hard on it ever since. So we need to all thank Professor McGinnis. I also need to second Tavianis's thanks to all members of the Missouri Law Review. They have worked very hard on this, as you know, and the participants will learn quite personally this weekend. They are continuing to work on it, and as perhaps they don't fully appreciate it, they will continue to work on it with the papers that you all will be presenting here this weekend. So we thank them in particular. In addition to Robin Nichols, we need to thank Casey Baker, Scott Weiser, and Risa Kearns, who are staff members who worked particularly diligently in all of the efforts both this weekend and leading up to today. And finally, we thank all of you for participating, speaking. You will be introduced as the symposium develops, but we want to thank you who have joined us as participants. It's now my great pleasure to introduce briefly Professor Peggy McGinnis. After her graduation from American University, Professor McGinnis became a Foreign Service Officer with the State Department and served as Special Assistant to Secretary of State Warren Christopher. Professor McGinnis earned her J.D. degree from the Stanford Law School, where she served on the law review. Following law school, she clerked for Judge Colleen McMahon on the Southern District of New York, and then worked for Paul Weiss in New York City. Since 2003, she has served on our faculty, where she teaches in the areas of international law, international human rights, and federal courts. So would you please join me in thanking and welcoming Professor Peggy.
Thanks, Larry, for that kind introduction. I wasn't expecting that. So let me just echo and repeat the note of welcome and thanks to the folks on the Larby who helped make this possible, and welcome you all to the annual symposium. Duncan Holland asked me a couple of days ago whether we pronounce it Missouri or Missouri. And as a transplanted Northeasterner, I can say after lots of empirical observation that there are two categories of people who pronounce it Missouri. This is real empirical evidence here. The one category, the politicians who are running for statewide or national office, always pronounce Missouri. The other category is the dean of the law school whenever he's addressing a group of alums who he'd like to solicit large donations from. So I can say, you can take your hands off your wallet. He's not going to give you money today. But I do want to thank Dean Dessum and Tavi and all the members of the law review, in particular Will, Markenthal, and Chuck, who are still last week, our last arrivals here, for all the heavy lifting on organization and logistics, and to Robin for getting you all here safe and sound. Before turning to the sort of ground rules and turning it over to the first panel, I wanted to say a few words about the theme of the symposium and describe, especially for those of you in the audience, and we're going to be webcasting this starting Monday, especially those coming to these issues for the first time, I wanted to sort of describe the terrain we're going to be exploring today. So the point of departure is the 1920 case of Missouri v. Holland, in which the Supreme Court upheld federal regulation of bird hunting in Missouri on the ground that the statutes had been enacted pursuant to the national treaty power and were therefore not subject to the limitations on congressional power enumerated in Article 1 or to the federalism limitations of the 10th Amendment of the Constitution. So the case is often described as standing for the basic proposition that the national government can do through treaty what it otherwise may not do through national legislation. And more specifically, the case is presented as standing for the proposition that limitations on the legislative power of the national government do not apply when the national government ratifies a treaty that is self-executing, that is, does not require implementing legislation to be given effect, or enacts legislation that otherwise would be outside the enumerated powers of Congress, can be considered constitutional so long as its legislation implementing a valid non-self-executing treaty. Now, I'm going to talk a little bit about the story of the case. I don't want to tread too much on Ed Swaine's wonderful paper, which gets into some of the interesting local politics and details of the case. But it's a case that starts with sort of a classic collective action problem, regulating the hunting of migratory birds. Now, when the European settlers arrived in North America, the skies were dominated by hundreds, literally hundreds of species of migratory birds. By the late 19th century, the unregulated hunting of migratory birds for both meat and for plumage, the high demand of ladies' hats at the time required feathers, had reduced the species of many, or reduced the population of many species to near extinct levels. Migratory birds are especially vulnerable due to the habit of nesting in large numbers, making them an easy target for market hunters looking to take high quantities of meat in the most efficient manner possible. The proverbial city ducks, as it were. And so the one story is sort of illustrative, the plight of the, I'm sure I'm going to mangle the pronunciation, Ectopistis migratorius, otherwise known as the passenger pigeon. Once the most populous species of bird in North America, naturalists estimate that there were as many as 5 billion passenger pigeons in North America at the time of the arrival of the Europeans. They were so numerous that the flocks of these migrating birds would cover distances of 300 miles long and several miles wide, over a mile wide. And they were so densely clustered in their migration that they were said to block out the sun for hours at a time and on occasion days at a time. Yet by the end of the 19th century, the passenger pigeon had been hunted to the brink of extinction, and the last bird was in captivity at the Cincinnati Zoo. Her name was Martha, and sadly she died in 1914. So the passenger pigeon is sort of illustrative of this rapid depletion of the migratory bird stocks in North America. Prior to 1900, there were no federal laws at all regulating the capture of migratory birds, but rather you had a patchwork of state and territorial rules governing hunting and capture. So you had the states facing a classic tragedy of the commons. Right? Bird hunting filled a commercial need, but with no coordination of rules among the states, overhunting was leading to this near extinction of several bird populations. And interestingly and importantly, it was leading to near extinction of several important insectivorous species that were essential to increasing and maintaining agricultural yields. So you have a movement for national regulation starting around the turn of the 20th century, interestingly, from the ground up, with state game officials coordinating with national conservation organizations and sports teams organizations. You might think of them as the forefathers of the modern environmental NGOs, names like the American Ornithological Union, the American Game Protective Association. They were joined by the interests of the then very, very, very small national government through the Department of Agriculture. With that department was increasingly focused on this problem of the depletion of insectivorous birds and the impact on crop yields. So this alignment of interest resulted in the 1900 Lacey Act, which attempts to overcome this tragedy of the commons by making it illegal to engage in interstate transport of birds or wildlife taken in violation of state or territorial law. Fortunately, the weak enforcement provisions of the Lacey Act proved inadequate to the task of overcoming the huge market demands for these birds. So Congress gets tougher and comes up with the Weeks-McLean Law of 1913, which deemed all migratory game and insectivorous birds that pass through the borders of any state or territory to be within the custody of the U.S. government, and prohibited the destruction or taking of those migratory species. Now, as Ed Swaine discusses in his paper, and as Charles Loughran discusses in detail in his 1975 Supreme Court review article on the case, even at the time the Weeks-McLean Law was passed, its proponents were a bit concerned about its constitutionality. And as its proponents feared, two federal courts struck down the law as unconstitutional, as being outside Congress's enumerated powers, and rejecting any arguments which was in accordance with the court precedent at the time that the regulation of game found within the borders of a state could be accomplished by Congress through the Commerce Clause. Now, by that time, Senator Elihu Root, who just a few years earlier had founded the American Society of International Law, had suggested to the proponents of these migratory bird statutes, or the McLean Weeks statute specifically, that they might consider the use of treaty as a solution to any constitutional infirmities. So, following this suggestion, in reaction to the two court decisions striking down the statute, the U.S. negotiated and ultimately the Senate approved. The United States ratified the Migratory Bird Treaty with Great Britain, which at the time was acting on behalf of Canada, and that was passed in 1916. That was ratified in 1916. Congress passed the implementing statute for that treaty, the Migratory Bird Treaty Act, in July of 1918, at which time Woodrow Wilson signed the act. Now, I might say one tangential aside of Missouri history that you might find interesting. Later that year, President Wilson goes off to the Paris Peace Conference with a new young advisor in tow, a native Missourian and professor of law from the University of Missouri named Manly O. Hudson. For those of you who are mainly O. Hudson fans, his middle name, by the way, is Ottner. That's the first time I read that. Hudson, of course, would go on to teach as the Bemis Professor at Harvard and become the first American judge on the League of Nations Permanent Court of International Justice, one of the drafters of the UN Charter, and also drafted the Statute of the International Court of Justice. Now, Time magazine referred to him in 1936 at the time of his investiture on the League Court as, quote, invincibly small town, unquote, which I think is an interesting description of one of the leading internationalists of the 20th century, and perhaps a useful reminder of the dangers of the tendency to essentialize the quote-unquote local and international, as Judith Resnick has warned us. So, as the peace negotiations are opening in Paris, promising, not for the first time, a new world order under international law, opponents of this new Weeks-McLean law, which included the so-called market hunters and also some avid recreational hunters, who were concerned about federal oversight of their sport, looked to challenge the statute. And they found it when the federal game warden, Ray Holland, arrested and indicted a few Missourians caught with some ducks, hunted out of season in violation of the new statute. And by the way, as a sort of homage to the case, duck is one of the choices on tonight's menu. I couldn't get the restaurant to vouch for its origin or the terms of its capture. So the state of Missouri sought to enjoin further action by Warden Holland, and Judge Van Valkenburg of the Western District of Missouri dismissed Missouri's application for an injunction. In so doing, Valkenburg remarked that without the treaty, the act surely would have been unconstitutional. It is from this opinion, then, that the state of Missouri appealed to the Supreme Court that led to the famous decision by Justice Oliver Wendell Holmes. His decision, in turn, immediately aroused fears over the use of the treaty power as an end run around our constitutional order, which was envisioned as one of dual sovereignty or dual federalism, a national government of limited enumerated powers, leaving other functions and powers to the states and the people. And those fears are manifested in the institutional backlash, first by the efforts of Frank Coleman, then president of the American Bar Association in the late 1940s, and later taken up by Senator John Bricker of Ohio to amend the Constitution. To their minds, to Holman and Bricker, the precedent set by Holmes would permit international legal commitments to blanket the sky, sort of a metaphor of the migration of the passenger pigeons of yore, blotting out the police powers of the states and overshadowing the limitations on congressional and presidential power. Now, these efforts to amend the Constitution sought to limit the scope of the treaty's power, the use of executive agreements, in order to prevent the president from committing the United States to many of the broad post-World War II internationalist projects, and in particular the emerging international human rights system, under which many of the practices of the states, in particular the institutional segregation, discrimination, and Jim Crow South, would be found in violation. Now, these amendments failed, but the idea of American human rights exceptionalism and the controversies surrounding U.S. participation in treaty regimes that give effect to individual rights, and what this means for political and legal theories of the value of federalism to our democratic order, are very much alive, as we will be exploring today. But let me introduce the panels briefly. Our first panel is going to return to the doctrinal debate over Missouri v. Holland, exploring the text, structure, and history of the Constitution to illuminate our understanding of treaty power, the Supremacy Clause, Article I powers of Congress, and the meaning of the 10th Amendment. Among the issues covered in the papers by Professors Vazquez, Ramsey, and Swaine, and also the commentary by Professors Golove and Rosenkranz, who previously staked out significant positions on these issues, are what, if any, are the subject matter limitations on the national treaty power? Is there or should there be a limit on Congress's power to legislate pursuant to the treaty clause? Or, as has been argued, are there structural federalism limitations to national power that suggest that the states are the proper bodies to enact non-self-executing treaties? Panel 2 will then turn to the role of state and local governments in international rulemaking. Professors Koo, Hollis, and Stephen will explore the scope of state and local power and competence to participate in legal and political processes across borders. In so doing, they will address how and why states and localities participate in international lawmaking. What, if any, constitutional constraints should there be on these activities? Under general political theories of federalism, are vertical constraints on local and state activity optimal? Why is it that the national government is largely absent from the process of transnational private lawmaking? And are these bottom-up processes of private rulemaking operating horizontally across jurisdictions effective in overcoming the regulatory coordination problems inherent in the federal system? Our keynote speaker, Professor Judith Resnick, will then offer her perspectives on the internationalism of American federalism, her work exploring the ways in which American federalism permits local and state entities to engage transnational legal and political processes. At the same time, Professor Resnick's work raises notes of caution about the implications of how the foreign or international becomes domestic through these multiple ports of engagement. Our final panel will address the migration of law and norms, both figuratively and literally. Professors Adia, Berman, and Soman will examine the complexities of a legal order that includes regulation at multiple levels, local, state, national, and international. Each provides a unique lens on whether we should view overlapping, inconsistent, or simply divergent legal orders as problematic from the perspective of democratic participation in lawmaking, or as an opportunity for robust competition and contestation that can promote democratic outcomes. Should we, for example, view jurisdictional conflict, redundancy, and competition as an obstacle to the international rule of law, or are there values in complexity? Now, without preempting any later discussion, I just want to add sort of my own idiosyncrasies and perspectives on the direction of scholarship in this area, whether we call it international law scholarship or foreign affairs scholarship. I think, as evident from the lineup of the panels and the variety of perspectives being brought to bear on this topic today, I've taken an eclectic view of what is of value. The history and development of constitutional doctrine certainly remains at the center of any discussion of the intersection between constraints on the exercise of governmental power within the United States and the legal and political engagement that the United States participates in internationally. But I really believe those doctrinal approaches are enriched by alternative approaches, drawing from, for example, legal realism, the law society movement, transnational legal process, legal pluralism, and from outside disciplines like economics and international relations theory. It is my hope that the spirit of methodological diversity, in which each of us learns something from the approaches and perspectives of others, will enrich the debates here today and as we go forward about the relationship between American federalism and international law. Now, finally, I do want to thank all the presenters and commentators who come in today from both coasts, East and West Coast, and points in between, from the coast to the bluffs of the Missouri River, for what I predict will be a lively and thought-provoking day and a half for all of us. So now for the ground rules. We'll proceed with each panel as follows. Each of the presenters will have 15 minutes to present their papers, followed by no more than 10 minutes each of commentary from our two commentators. We'll then have an opportunity for some crosstalk and perhaps their reply, and then open it up for Q&A from the audience. We haven't assigned official moderators. I will be perched in the front row as an unofficial moderator should things come to fisticuffs. But I will try and keep this on track in terms of the order of questions from the audience, and we have a timer in the front row to keep you on the panels all on track as well. So with that, I will turn it over to the first panel and Professor Vazquez.
Thank you. I want to thank the organizers and Professor McGinnis for inviting me. This is one of those happy occasions where I was invited to present a paper that I had already written. In fact, I wrote it over a year ago, and mine was probably the first paper in by a wide margin. This is a situation I don't usually find myself in, and it has its benefits, but it also has its disadvantages. The disadvantage is that I was up late last night working on a different paper, finishing a paper for a conference that took place in October, which is the situation I usually find myself in. And so what that means is I haven't actually even looked at my own paper for about a year until this morning. So forgive me if I'm a bit rusty on my own arguments. Anyway, I wrote this piece in response to articles by Professors Bradley and Rosenkranz, separate articles by Professors Bradley and Rosenkranz, which advance a critique of Missouri versus Holland that was unlike prior critiques, in my view. As Nick Rosenkranz notes in his articles, the Missouri versus Holland's holding consists of two separate propositions. First, that a treaty beyond Article 1, Section 8 is itself valid. The treaty can be made consistent with the Constitution, even if it goes beyond matters of Article 1, Section 8. The second proposition is that if the treaty is valid, then Congress has the power to implement it if the treaty requires implementation. Most critiques of Missouri versus Holland focus on the first point, and that's the point that Justice Holmes focused on in his opinion. The criticisms of Missouri versus Holland generally take the form of that the treaty should not be made if it goes beyond Article 1, Section 8. The Constitution prohibits such treaties. Very few people had, up until recently, contested the second proposition, which is that if the treaty can be made and requires implementation, then Congress can implement it. Professors Bradley and Rosenkranz both take on the second of those two propositions. And in my view, this seemed to me to be very directly in conflict with the founders' design with respect to treaties. It seemed to me completely implausible. And so I found myself, I wrote this piece and found myself somewhat surprised to actually reach a conclusion that is similar in some respects to those of Professors Bradley and Rosenkranz. In the end, I argue that it is in fact the second proposition of Missouri versus Holland that does need some alteration, some modification. However, my proposed modification of this Missouri versus Holland second holding, I think, is far narrower than those proposed by Professors Bradley and Rosenkranz, and I think is consistent with the founders' design, whereas I think the conclusions of Professors Bradley and Rosenkranz are inconsistent with the founders' design. My proposition, I think, my conclusion constitutes tinkering around Missouri versus Holland's edges, whereas Bradley and Rosenkranz would both scrap Missouri versus Holland entirely. All right, let me just briefly describe the arguments of Professors Bradley and Rosenkranz at a very general level. I won't get into the for lack of time, I won't get into the specific arguments or my specific responses. I will briefly describe the arguments and then briefly describe my alternative position. As I indicated, Professors Bradley and Rosenkranz both take on the second proposition. They don't disagree with the Missouri versus Holland on the first point. That is, they agree that treaties may be made that go beyond Article 1, Section 8. And they also agree that such treaties may be non-self-executing. Their position, though, is that if a treaty is made beyond Article 1, Section 8 and is self-executing, Congress does not have the power to implement them. Professor Bradley would also takes the position that such treaties cannot be self-executing, and therefore such treaties are necessarily require congressional implementation, yet Congress, require implementation, yet Congress doesn't have the power to implement them, meaning that it's up to the states to implement such treaties. Professor Rosenkranz's argument is different in that he accepts that such treaties can be self-executing. Therefore, his position is less problematic in that the federal government does have the power to effectively implement such treaties by making them self-executing. But nevertheless, Professor Rosenkranz recognizes that the treaty makers can make such treaties non-self-executing, and if they decide to do so, then Congress would lack the power to implement them. My main objection to this position is that it is in direct conflict with the founders' design. It's well known that one of the principal animating causes of the decision to write a new constitution was the fact that states were not complying with our treaty obligations. The experience under the Articles of Confederation showed that states could not be relied upon to implement and comply with treaties, and therefore it was universally agreed at the convention that the power over compliance with treaties had to be placed in the national government. And so the founding debates show that the principal way that the founders dealt with this was by giving treaties the status of supreme federal law. In other words, treaties became self-executing through the Supremacy Clause. The Supremacy Clause effectively executed our treaties in advance. I agree with Professor Rosenkranz that self-execution of treaties was the paradigm in the founders' view. Nevertheless, the concept of non-self-executing treaties has come to be accepted and come to be entrenched, and neither Professors Bradley nor Rosenkranz argues that the Constitution prohibits non-self-executing treaties. If we're going to recognize non-self-executing treaties, then I think the conclusion most consistent with the founders' design is that if a treaty needs implementation, then Congress has the power to implement it. It seems to me that if the founders had regarded the treaty power as limited by Article 1, Section 8, they would have prohibited such treaties going beyond Article 1, Section 8 from being made in the first place. If they had, on the other hand, allowed treaties to be made that go beyond Article 1, Section 8, they would have insisted that Congress have the power to implement them. Better to have no treaty at all than to have a treaty that is in force yet beyond the power of Congress to implement. That's my basic objection to both arguments, the arguments of both Professors Bradley and Rosenkranz. As I indicated, though, in the end, I agree that Missouri versus Holland needs some tinkering, and that it's the second proposition that has to be rethought. And so let me focus the remainder of my comments on my affirmative alternative proposal. Well, first, both Professors Bradley and Rosenkranz seem to be concerned about the use of the treaty power to evade the limits of Article 1, Section 8. They seem to be concerned about a bad faith use of the treaty power to, for example, achieve the enactment of a gun-free school zones law, where such a law could not be passed directly under the Commerce power. I think this concern is overstated. I think in my view, the requirement that treaties be approved by 2/3 of the Senate is a sufficient structural protection against such bad faith treaties. I have trouble envisioning a bad faith treaty of that sort getting through the Senate. But I do think that there's a somewhat different problem that does exist, and that it's a legitimate federalism concern with respect to Missouri versus Holland. I think there are many good faith treaties already in force that are extremely vague and aspirational, and if Missouri versus Holland permits the federal government to pass statutes in pursuance of or in implementation of such treaties, then the federal government effectively already has plenary legislative power under existing treaties. An example would be the UN Charter, which contemplates that member states shall promote human rights, a very vague and aspirational treaty provision which was held in Sei Fuji to be non-self-executing. If Congress has the power to execute a provision of that sort by passing statutes that go beyond Article 1, Section 8, then effectively Congress has plenary legislative power, and the federalism limits articulated in cases such as Lopez are really beside the point. I do think that is a legitimate federalism concern. However, I don't think that it requires scrapping of Missouri versus Holland entirely. My alternative proposal is that Missouri versus Holland be limited to treaties that are specific and obligatory as opposed to vague and aspirational. In other words, that vague and aspirational treaties would not be treaties that could be implemented by Congress under Missouri versus Holland if they go beyond Article 1, Section 8. If they fall within Article 1, Section 8, of course, the statute could be passed. If they go beyond Article 1, Section 8, then any implementation must come from the states. This is a much narrower position than the ones that Professors Bradley and Rosenkranz put forward, in that they would entirely scrap the second proposition of Missouri versus Holland, and so under their view, even specific and obligatory treaty provisions could not be implemented pursuant to the treaty power if they go beyond Article 1, Section 8. An example that I give in the paper is of a specific and obligatory treaty provision that, under my view, would be subject to implementation by the federal government, yet under their position would not be, is the provision of the ICCPR, the Covenant on Civil and Political Rights, that prohibits the execution of pregnant women. This treaty has been declared to be non-self-executing, and therefore this provision, if pursuant to that declaration, does require implementation. It's very specific and obligatory. It's a clear prohibition of the execution of pregnant women, and its scope is limited and specific. I think under my theory that Congress would have the power to pass a statute prohibiting the execution of pregnant women pursuant to this provision, yet under Professors Bradley and Rosenkranz's views, it seems to me that Congress would not have that power. When you have a vague and aspirational provision, however, the views of the conclusion of Professors Bradley and Rosenkranz are the same as mine. It's a much narrower position, and it's also, in my view, consistent with the founders' design, whereas the opposite position is inconsistent. The founders' design, as I explained in the paper, was to leave, to place the question of compliance with treaties in the hands of the federal government. It was thought to be completely unacceptable to have the question of compliance with treaties be left to the states, which under the experience of the Articles of Confederation had been shown to be unreliable protectors or compliers with treaties. Well, vague and aspirational treaty provisions, such as the UN Charter's obligation to promote human rights, are provisions that don't really raise compliance issues in the sense that it's hard to identify what a violation would look like. Therefore, since it is vague and aspirational, and many different different sorts of implementing legislation would comply, and even failure to enact anything would not produce an identifiable violation. Because of that, we can leave the question of implementation to the states if the matter falls outside of Article 1, Section 8. And so my position is consistent with the founders' intent if one views the founding design as ensuring that the question of compliance with treaties is placed in the hands of the federal government and not left to the states. With respect to vague and aspirational treaties, compliance issues simply do not arise. And in that respect, I think this modification of Missouri versus Holland would be consistent with the founders' intent. And I should add and close with this that it does, my proposed rule would require a modification of the holding of Missouri versus Holland, in the sense that if one applied my test to the facts of Missouri versus Holland, it does appear that a different conclusion would have been reached, because, at least as described by Justice Holmes in his opinion, the treaty involved in Missouri versus Holland did not actually require the enactment of any legislation. It simply required the parties to propose certain legislation to their legislatures. And so under my test, since enactment of legislation was not required. It would not have violated the treaty not to enact the statute that Congress enacted in this case. Therefore, on the facts of Missouri versus Holland, my test would not have been satisfied, and a different result would have been reached. But again, I think even though it does require a modification of the actual holding of the case, the modification that I propose is far narrower than the one that is proposed by Professors Bradley and Rosenkranz, and I think it's much more consistent with the founding design. Thank you.
Thanks. First of all, thanks for inviting me and for hosting this wonderful event. Following Carlos's lead, let me say a few words about what motivated this paper, which is somewhat different than what motivated his paper. Besides, obviously there was a tempting offer to appear here and the burdens of pre-commitment, in the sense that I committed to writing a paper, and here you have it. It seems to me this was a nice opportunity to think about Missouri versus Holland as a case on its own terms, and to understand its background a little bit better. It also gave me an opportunity to pursue sort of a suspicion that I have long had that there are incomplete theories about the domestic force of treaties, primarily but not exclusively relating to their non-self-executing status, and that these have long plagued U.S. case law, including but not limited to Missouri versus Holland. Most broadly, I'm dissatisfied in general, I'm not dissatisfied in general, I'm quite content in general, but I'm dissatisfied generally with what I think of as congruence reasoning within foreign relations law. And that is the sense that either the external treaty power or the internal treaty power should correspond closely with the scope of domestic authority, or vice versa, the converse commitment to the view that the domestic authority to implement needs to correspond closely with the external power to forge these commitments. And I'm particularly suspicious of views that this congruence needs to be enforced in the form of constitutional reasoning enforced by the judiciary. I tend to think that this congruence is fatally undermined by dramatic changes we've had since the framing in the treaty power scope, in domestic powers scope, and also changes, as a number of these papers suggest, in the scope of what we think of as self-executing treaties. And I think Missouri versus Holland is a proving ground. So what my paper is about is basically, in essence, is what does it mean for a treaty to require legislation, and what does Missouri versus Holland actually say about that question? Part of the paper is sort of self-indulgent discussion of the background in the context of Missouri versus Holland. Parts of the legal story of Missouri versus Holland are very well understood and repeated within virtually every paper ever published, including mine, on this subject. The basic story is, the domestic legislation was struck down, that the treaty and Holmes were sort of, my Latin will fail me, the plural of deus ex machina, and that there was, this resulted in a political and constitutional neutering of the issue for a while, and then this has been revived under the Rehnquist Court when we appear to have perhaps reinvigorated limitations on domestic authority. This is the standard account. One thing that I found in looking into the background of this is how contingent this really all was at the time of Missouri versus Holland. One aspect that the paper explores is the collision of the personal and regional interests that were represented in this, and Peggy's introductory remarks touched on that. There really is a strong Missouri, I will indulge that because I'm of Iowan stock, a Missouri impulse. There was also great uncertainty about the constitutionality of the federal legislation. It wasn't a given that it was going to be held unconstitutional. There was divided authority in the lower courts, and the Supreme Court itself was apparently divided precisely on this question. It was split. It was also quite uncertain as to whether there would be successfully concluded a treaty with Great Britain on behalf of Canada, especially with the onset of war. And finally, it was not at all clear that there was going to be successful implementation of that treaty. Though one gets competing impressions from reviewing the congressional record in this regard. There was a very vigorous debate in Congress. There was consideration of alternative courses, such as whether there might be implementation by the states, whether there ought to be instead a constitutional amendment, which is something I know that Professor Rosenkranz's work has touched on. Overall, though, it suggests that many of the questions we now regard as settled were contingent at the time. One thing this taught me, at least, is that one shouldn't be too sanguine that the power of Congress to implement a treaty, assuming it exists, is going to be effectuated. And we shouldn't fool ourselves into thinking that the U.S. Performance of treaty obligations is going to be secured by the availability of necessary and proper implementing power. A second thing it taught me, at least, was there are alternatives to the judicial role. Frankly, looking at the record of this briefing of these issues in the Supreme Court versus the record in Congress, it's hard to say who really came out the better. Certainly the issues percolated in a more effective way, a more scattershot way in the congressional debates, but it was probably an improvement over the way the litigants handled it in Missouri versus Holland, and certainly over the Delphic pronouncements of Justice Holmes on this matter. Why it really seems these issues seem contingent at the end of the day is because Holmes's reasoning seems so insufficiently determined. My paper is about the second aspect of Missouri versus Holland, the proposition that if the treaty is valid, there can be no dispute. Well, we don't really know that. We know that there really wasn't a dispute in that litigation, effectively. But he might have meant many things by that, and the rest of the paper tries to examine what that might mean. One thing he might mean is that it was really beyond legal dispute, that there was no grounds for disagreeing about this proposition. I'm somewhat sympathetic to that, and part of the paper discusses or tries to oppose in a mild way the restrictive understanding of the necessary and proper clause, the proposition that as Professor Rosenkranz has elegantly put it, it's really only there to assist in the power to make treaties, and it's exhausted once those treaties are made. I come to grips a little bit with that, or indicate some mild skepticism about that as a matter of textual construction and as a matter of understanding the history of the formation of the necessary and proper clause and the treaty power, in part because I really, at the end of the day, don't know how we are to interpret the confidence of the framers that the necessary and proper clause added little. We simply don't know what they meant by that. If that was founded on an expectation that treaties would characteristically be self-executing, then of course the necessary and proper clause would add very little, because treaties themselves would have accomplished everything possible. The necessary and proper clause, as pertinent to the treaty power, would have added virtually nothing. Anyway, I indicate some skepticism about that. But then the rest of the paper tries to deal with what Holmes might have been saying about the scope of the implementing power and what he must have been saying. In other words, what the decision in Missouri v. Holland might mean narrowly construed. My position at the end of the day is that the non-self-executing status of the Migratory Birds Convention is effectively overdetermined. There's a number of different ways that it might have been understood to be a non-self-executing. The standard version, I think, is that it was non-self-executing because the treaty makers decided that it would be so. There was a provision in the convention that said, basically, go forth and propose legislation. Carlos's final remarks alluded to this. It's not clear what that means exactly. It may have been catering to Canada's unique position, which did not have the capacity to indulge in a self-executing treaty, and certainly Great Britain wasn't, which was negotiating the treaty on Canada's behalf, wasn't going to assume that. It needed to go through several steps. It needed to propose this, in effect, to the provinces and get their consent. So this may have been an instance in which non-self-execution was dictated by our treaty partner. Had nothing to do with the U.S. constitutional structure, and the treaty makers might well have assumed that on the U.S. side it was self-executing, or at least that's a possibility. Another possibility is that it was intended to refer, or the non-self-executing status within the United States was in consequence of the fact that some of the provisions required, or at least permitted, regulatory implementation, such as expanding the open season for certain kinds of birds, There were provisions in there that basically said, here's what hunters may not be permitted to do, but if under properly promulgated permissions adopted by the necessary authorities within each jurisdiction, certain exceptions might be afforded for emergencies or for crises or for the need to placate local audiences. And so we might think of it as being non-self-executing in that permissive sense as well. The final possibility that I explore is that perhaps it was non-self-executing again on the U.S. side, in part to accommodate what we think of as constitutional non-self-execution. The idea that Congress alone can be entrusted to do certain kinds of things. And it's mysterious as to how this proposition ever arose, but the idea is, in particular, that if it involves a criminalization of conduct or establishing a new offense as criminal or enhancing a punishment, it needs to be adopted by Congress. So at the end of the day, who cares? I mean, why do we care what the theory is as to why implementing legislation was necessary if, in fact, legislation was adopted? After all, we have to evaluate the constitutionality of that legislation. I speculate at the end of the paper in a very inconclusive and a way that I will be able to flesh out with the assistance of the law review editors, no doubt, what that might mean. First of all, if it's purely elective, that is certainly troubling, I think, under either Carlos's view or Nick Rosenkranz's view. If we have pursued legislation under the treaty only because we as the United States chose to, it wasn't necessitated by the treaty at all, it's simply something that is generated by, for example, our desire to have certain kinds of regulatory exemptions or to add criminalization of conduct that wasn't required under the treaty, that's potentially problematic because that's an instance in which the treaty has not itself established this power, but it's something that U.S. Policymakers have adopted to add on as a bell or whistle onto the treaty. And so that is potentially problematic and perhaps isn't redeemed by anything in Missouri versus Holland or anything in an expectation that we need to at least be able to keep our international promises. If we're going beyond our international promises, then perhaps Missouri versus Holland shouldn't go very far. On the other hand, it is a slightly different proposition if we feel that Congress is required to take these steps because constitutionally the treaty makers cannot go any further. We might think that that is part of the necessary and proper authority vested in the national government as a whole, is to establish a full range of treaty commitments and coincidentally to bring them into full being domestically, if and to the extent they're constitutionally disabled from doing otherwise. We might think, in other words, more kindly about these kinds of treaty commitments and their ability to implement them domestically if a self-executing treaty could not by itself get the job done. The proposition on the table in the alternative is very often, well, just forge a self-executing treaty, that would be supreme law under the Constitution. But if you cannot do so, because of this doctrine that suggests that certain things are beyond the power of a self-executing treaty, then I submit to you that frames the question at issue in Missouri versus Holland somewhat differently. So why don't I stop there and make further remarks during the cross-examination period.
All right. Well, thank you very much for having me here to talk on this great topic in this great case. I am going to address what my fellow panelists have called the first question of Missouri versus Holland, which is whether the treaty power can extend to subjects beyond Article 1, Section 8, which limits Congress. What I would like to do in particular is to look at what the original understanding of the Constitution was on this point and to criticize some originalist approaches that have reached a contrary conclusion. I'd like to say in the interest of disclosure and self-promotion at the outset that these remarks build upon a chapter on Missouri versus Holland in my book, The Constitution's Text in Foreign Affairs, and I would like to thank Harvard University Press for permission to do this, which I'm sure they will give me as soon as I ask them. I would also like to acknowledge the fantastic historical work of David Golove, which my history is greatly indebted to, if not derivative of. What I'd like to bring to the discussion is a bit of comment on methodology, because I feel that lack of a definitive methodology has led some originalist considerations of this topic somewhat astray. And I'd like to point out how I think that's happened. I'll say also at the outset that I come to this topic somewhat conflicted as someone who has written extensively in defense of constitutional federalism on the basis of the original understanding. I somewhat share the intuition of some of my fellow originalists that the treaty power as construed by Justice Holmes in Missouri versus Holland seems to be a great threat to federalism, and that some closer scrutiny of it should be given than Holmes was willing to give in the case. However, after further study, I've come to the conclusion that in fact Holmes had it right, although I'm not sure he deserved to, and that many of my fellow Federalist sympathizers have been led astray by what I regard as an insufficient focus on the constitutional text and its specific context. What I've tried to describe in the paper is an approach that I call historical textualism, which does urge that dual focus, that is, first upon particular clauses of the Constitution that are supposed to, that we are supposed to construe to lead us to the conclusion that we are advancing. And also, because I don't mean to suggest that the Constitution can be read in isolation from its context, and also the historical context in which these clauses were drafted, and in particular their linguistic context which they arose from. But at the same time, what I want to do is keep the focus carefully on the text and not let it drift too far into general ideas about federalism. And I think that focus, as I'll try to illustrate, can help to avert the natural tendency to substitute one's own idea of the best Constitution for the one that the framers actually wrote. Now, the paper provides an affirmative textual and historical case for Missouri versus Holland, that is, for the first proposition that the treaty power can extend beyond the Article 1, Section 8 powers. And I'm going to skip that and proceed directly to my criticisms. And because I'm not so bold as my fellow panelists, and because my subject allows me to, I'm going to, rather than criticize people who are actually in the room, I'm going to limit myself to criticisms of two people who were not invited and one person who is dead. He couldn't make it, though. The first person that I want to take on is Henry St. George Tucker, who is dead, but he wrote perhaps the leading treatise on treaty power at the time that Missouri versus Holland was being developed. The book actually came out in 1915. I'm sure that he had the developing controversy in Missouri versus Holland in mind. Tucker, I will say, was a leading academic lawyer and law professor of his time. He was also either, and I regret that I've forgotten this, either the grandson or great-grandson of St. George Tucker, one of the great commentators on the Constitution in the early 19th century. But Tucker felt quite strongly that the treaty power did not extend beyond Article 1, Section 8. And he derived this almost entirely from a structural intuition, that the states can be destroyed by an unlimited treaty power, and that the careful limits upon federal power elsewhere in the Constitution would be negated if we were to recognize such a treaty power. As Tucker said in his book, the argument is irresistible that if the whole scheme and genius of the Constitution was to save the ungranted powers of the states from interference by the federal government, that the framers of the Constitution would not have secured these against the ravages of all departments of the government, and then quietly bestowed upon one of its branches, the treaty power, the power to absorb them all. Or as he went on to say, the contrary view drives us to this dilemma, that the Federal Convention, after weeks and months of intense labor in adjusting the views of the opposing factions in the convention, and after arranging with delicate touch the location of each power, local and national, that after all this was concluded, in order to induce harmony and produce unity where discord had reigned, they had agreed practically in the last article of the Constitution to sweep it all away by the introduction of a power which recognized none of the limitations or restrictions theretofore laid upon the federal government. The problem with this argument, in my view, is that it does not rely on any particular language in the Constitution to sustain it. It is rather, as I've said, entirely a structural intuition. And there are two further problems with that. First, if you take just an initial look at the Constitution, you will not see any limitations on the treaty power in terms of subject matter. It is true that there are limitations in Article 1, Section 8 that Professor Tucker emphasized, but in fact, those to me seem to cut in the opposite direction because the framers knew how to write limits with respect to subject matter. They did it very carefully in Article 1, Section 8, and they did not do it in Article 2, Section 2, where the treaty power is granted. Further, there are textual limits on the treaty power. They're just not the kind that Professor Tucker wanted. The treaty power is limited by procedural restrictions. That is, the familiar requirement that 2/3 of the Senate must approve treaties. I think it's worth further emphasizing, though, because we may tend to forget these things in the modern era, that to the framers, 2/3 of the Senate meant 2/3 of the representatives of the states. Because prior to the 17th Amendment, senators were selected by the state legislatures pursuant to Article 1, Section 3. When the framers put the treaty power in the hands of the Senate, they in effect put the treaty power in the hands of the states. Now, it may be that this protection is not enough. The Anti-Federalists thought it was not enough during the ratification debates and said so on a number of occasions. But it's also quite plausible to think that the framers did think it's enough. That is, the question whether the procedural protections which appear on the face of the Constitution with respect to the treaty power are sufficient to protect federalism or not is a value choice, not an obvious conclusion. Tucker said the argument is irresistible, but I think it actually can be resisted. In fact, even after the 17th Amendment was adopted, some very prominent people, including Herbert Wechsler, have said the, quote, political safeguards, unquote, of federalism, that is, the difficulty of enacting legislation and concluding treaties, are sufficient to protect the states in our constitutional system. And so I think that what Tucker meant, rather than it being irresistible, was that he thought it was plain. But without some claim based on text, there's no way to say that Tucker's view represents what the framers actually did, as opposed to what Tucker thought they should have done. I now want to turn to the leading modern defense of, the leading modern critique of Missouri versus Holland on this point, which is Gary Lawson and Guy Seidman writing in the Illinois Law Review 2 years ago. Gary Lawson, one of the greatest and certainly the most amusing textualist writer of our day, coming to the conclusion that the same conclusion that Tucker did. Now, Lawson and Seidman quite a bit more sophisticated than Tucker, and as good textualists, they do start with the text. They find a somewhat strained, in my view, but I'll give it to them, reading that generates an implicit limit on the treaty power. They say that the treaty power is implementational. That is, that it only allows implementation of powers vested in the federal government. Elsewhere, in the document, and they conclude that from an implicit limitation on executive power, which they say can be found in the history and the framers' understanding of the role of executives. Without going into that a lot of detail, what I would say about it at first is that it creates at most an ambiguity. That is, it's possible that the framers recognized this limitation on executive power, and possible that they didn't, because certainly there is an alternative reading of the treaty power that is the one that I've just set out, that is, that it's not limited by subject matter, but rather it's limited only by the procedural protections. Although I think that Lawson and Seidman start in the right place, they then, I think, move much too quickly and directly to Tucker's structural intuition. That is, they say, given that these two possible readings, that is, one that would give subject matter unlimited treaty power and one that would not, we should prefer the latter for essentially the reasons that Tucker gives. That is, as they say, as Lawson and Seidman say, if we are to credit the broader view, our federal system is only a president and 2/3 of the Senate away from destruction. Well, so be it, but I think that they have left out important steps. I think that you need to look not merely at the text, but at the text in its historical context. Let me give, in the interest of time, just one example of how I think the context drives us to the broader view rather than the Lawson-Seidman narrow view. In the Articles of Confederation, there was the exact same language with respect to treaty powers. The Continental Congress was granted the power to make treaties with no subject matter enhancement or limitation. Further, the Congress under the Articles of Confederation had very limited powers aside from treaty and other diplomatic and war powers. In particular, it did not have the power to make commercial regulations. Further, the Continental Congress under the Articles of Confederation was limited, as the Federal Congress under the Constitution is, to its delegated powers. In fact, even more strictly than by the Constitution's 10th Amendment, the Articles were limited to powers explicitly delegated to the Continental Congress. So, the Continental Congress had the treaty power. It did not have the power to regulate Congress. It did not have the power to do anything that was not explicitly granted. Nonetheless, the Congress under the Articles repeatedly entered into commercial treaties, and it sought to enter into quite a few more commercial treaties that other countries wouldn't have. So everyone knew that the power to make treaties was understood to include a power, commercial power, that the Articles did not otherwise give the Congress. As a result, there's no way that it could have been understood as implementational in the sense that Lawson and Seidman talk about it under the Articles. Now, of course, that doesn't mean that the framers had to adopt the same system as the Articles. But when they used the same language, and no one raised any objections on these grounds, it seems to me that the evidence leans much more heavily in favor of the understanding that is consistent with the Articles' understanding of the same text, rather than a reading of the text that Lawson and Seidman advanced that is not at least apparent on the face of the text and does not have substantial support in anything that the framers said at the time. And so, as a result, what I find is that if you take a historical textualist methodology seriously, that is, that if you focus on the text, you insist on a clause in the text or clauses in the text that lead you to the result that you are advocating, and then you set those clauses in their historical context as clauses, as language, not as some generalized idea about what the framers must have done because of a structural intuition that you have, you come more readily to a conclusion that is consistent with what the framers actually did. And in conclusion, and I've laid this out in some more detail in the paper, I find that approached that way, the first part of Missouri versus Holland, at least, is entirely consistent with the original understanding of the Constitution. Thank you.
Good morning. It's a pleasure to be here. I'd like to thank Peggy McGinnis and the Missouri Law Review for hosting this symposium and for including me. I'd particularly like to congratulate them on the topic of this panel, Missouri v. Holland, the treaty power, legislative powers, and the 10th Amendment. As we've seen, the title of this panel invites discussion of two of the great constitutional issues of treaty law. So first, what is the scope of the treaty power? Second, what is the scope of Congress's power to legislate pursuant to treaty? On the first question, Mike Ramsey has offered a masterful presentation. I have little to add to what he said. He chose not to criticize my work, and I think I'll return the compliment, except to applaud his explanation of historical textualism, which I think is quite useful, and his sensitive employment of that method to this issue. I'm inclined to agree that treaties can reach subjects beyond those in Article 1, Section 8. The one question I might pose to Professor Ramsey, it is possible that there could be subject matter limitations other than that. So Professor Ramsey offers quite a broad definition of what a treaty is, what a treaty can be, and says that that's the limit. Maybe we could have a little bit more discussion of that. So is the treaty power limited to something that is properly conceived of as a treaty, and what might that be? So maybe we can talk about that a bit further, but that said, I really have no criticisms. Now, Ed Swaine and Carlos Vazquez have focused our attention on the second issue, Congress's power to legislate pursuant to treaty. Now, this focus is particularly valuable because the second issue, is at least as important, but it has received far, far less attention. Justice Holmes himself addressed it in a single sentence, and it was almost entirely overlooked by the Legal Academy in the 85 years that followed until Kurt Bradley and I took it up a few years ago. So I applaud them for turning their attention to this crucial and understudied question, and for giving such rich and provocative presentations. So, is Congress automatically vested with power to enact legislation to implement a treaty, even though it would lack such power absent the treaty? Or to put the finest point on the question, can a treaty expand the legislative power of Congress? Now, the answer to this question turns on the relationship between two clauses of the Constitution, the Necessary and Proper Clause and the Treaty Clause. As a textualist, I'm a big believer in having a look at the words. So I'm going to go ahead and quote them. If you've got a Constitution in front of you, go ahead and have a look. Article 1 provides, quote, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof." Now, the treaty power is an other power vested by the Constitution and the President of the United States. So here then is the way these two clauses fit together as a matter of grammar. I'm going to add ellipses, right, and connect these clauses together. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the President's power, by and with the advice and consent of the Senate, to make treaties. Okay. The question is the scope of that power. What is a law for carrying into execution the power to make treaties? I contend that the key word here, the word that's been neglected, is the infinitive verb to make. This is not the power to make laws for carrying into execution the treaty power, let alone the power to make laws for carrying into execution all treaties. Rather, on the face of the text, Congress has power to make all laws which shall be necessary and proper for carrying into execution the power to make treaties. This power would certainly embrace laws appropriating money for the negotiation of treaties. It would, for example, clearly have justified the statute paying for John Jay's passage to Great Britain to negotiate what came to be known as the Jay Treaty. And Carlos Vazquez claims that a law implementing a non-self-executing treaty that has already been made would somehow still fit the bill as a law for carrying into execution the power to make treaties. But it's hard to see as a matter of textual logic how this can be so. As far as I can tell, the only possible answer to this point is to say, as Ed Swaine does, that the necessary and proper clause was not written with this level of grammatical or logical rigor, what Swaine calls the Rosenkranzian razor. This is a lovely compliment to me, but I'm afraid it's one I cannot accept. When it comes to grammatical and logical rigor, I think the framers have me beat any day of the week, and I think they knew exactly how these clauses fit together. In short, the text of these clauses hardly compels the result in Missouri v. Holland. Indeed, it appears to cut the other way. Constitutional structure likewise cuts the other way. Now, Mike Ramsey might disparage these as, quote, structural intuitions, and we could discuss how much weight they should carry, but there are two such structural intuitions here, and it's important to understand them both. The first is this. On my thesis, it is possible for the president to make a non-self-executing treaty that Congress has no power to execute. Carlos says this is inconceivable because it would recreate a central problem of the Articles of Confederation. But there's a basic conceptual error here. Under the Articles of Confederation, Congress could not ensure that its treaties would be executed. Under my reading of the Constitution, Congress can and generally will ensure enforcement by making treaties self-executed. Under the Articles, unenforced treaties were inevitable. On my view, they are merely an option. Giving the federal government power to enter into treaties and simultaneously enforce them is certainly a good idea, as the disastrous experience under the Articles of Confederation makes clear. But requiring the federal government to do so in each and every case is another matter. And of course, as Ed Swaine emphasizes, under countless doctrines that Carlos accepts, including the doctrine of non-self-executing treaties, as well as the doctrine that a subsequent statute can abrogate the domestic force of a treaty, the federal government already can opt not to fill its international obligations. There are many ways in which the United States can have an international obligation and choose not to enforce it. Many ways that Carlos thinks are okay. The fallacy here, in short, is that if providing something is good, then requiring it is better. The framers, though, understood that liberty is bound up with choice. They would not have made any such error. Now, the second high-level structural instinct at work here is much more powerful. If Carlos is right, then there are some statutes that will be beyond Congress's power to enact absent a treaty, but within Congress's power given the treaty. This means that the legislative powers of Congress are not fixed by the Constitution, but rather may be increased by treaty. In other words, the possible subject matter for legislation is not limited to those subjects enumerated in the Constitution. Rather, it's limited to those subjects plus any subject that may be addressed by treaty. And if Mike Ramsey is correct that there are no subject matter limitations whatsoever on the treaty power, then the legislative powers are not merely somewhat expandable by treaty, they're expandable virtually without limit. And one can imagine, for example, a treaty promising to regulate the citizenry so as to maximize the collective welfare. Under Missouri v. Holland, this treaty would confer upon Congress absolutely plenary legislative power. Now, needless to say, this proposition is in deep tension with the basic constitutional logic of enumerated legislative powers. If Missouri v. Holland is right about this, then treaty makers, who are the President and the Senate, will have the power to expand the subject matter jurisdiction of lawmakers, that is, the President, the Senate, and the House. Here there's no ambition to counteract ambition. Here instead, ambition is handed the keys to power. In short, the Constitution should not be construed to create this doubly perverse incentive. That is, an incentive to entangle the United States in additional international legal commitments, precisely to attain the desired side effect of more legislative power. Now, Carlos puts great stock in the two-thirds requirement, but under such circumstances, no supermajority requirement could be thought to stem the universal desire for power that the framers were so worried about. And neither text nor separation of powers theory permits this result. The Constitution provides exactly one method for the increase of the legislative power, and it's the mechanism of constitutional amendment in Article 5. Now, as you've heard, Carlos in particular disagrees with most of this, but I'd just like to end with the crucial point on which we do agree. In Missouri v. Holland, Justice Holmes wrote, this is the one sentence, quote, "If the treaty is valid, there can be no dispute about the validity of the implementing statute under Article 1, Section 8 as a necessary and proper means to execute the powers of government." This is perhaps the most important sentence in the case, perhaps the most important sentence in all of foreign affairs doctrine, and Carlos and I both think that it is wrong. Contra Justice Holmes, even if the treaty is valid, there can indeed be a dispute about the validity of the implementing statute. Now, Carlos and I disagree about precisely which statutes enacted pursuant to treaty are valid, but we agree on this crucial and revolutionary point. Justice Holmes was wrong. Even if a treaty is valid, implementing legislation might not be. And not only does Carlos agree that Holmes was wrong on this point, he further agrees that despite its canonical status, despite the fact that it was written by Justice Holmes, stare decisis should not stand in the way. Startlingly, in the final paragraph of his article, he agrees that partial overruling of Missouri v. Holland would be justified. Now, it's not fashionable at Georgetown to agree with me on these points, or indeed on any points, so I applaud Carlos on his courage, and I thank him for his support. Perhaps this should now be called the Georgetown School of U.S. Treaty Law. Thank you.
Great. Well, I want to thank Peggy and the University of Missouri Law School and the Law Review for inviting me to be here today and working so hard to get me here, which was a little bit difficult last night with problems with plane reservations and delayed flights and so on. Let me just say, since we've had a little bit of the micro history of Missouri versus Holland as a decision itself, let me add one other historical point which broadens the micro history just a little bit to talk about the larger setting in which the Missouri versus Holland dispute arose. Because in fact, and actually Secretary of State, later Senator Root, played an interesting role in this respect. The disputes over the subject of the issue that's at the center of Missouri versus Holland that Professor Ramsey spoken about go actually back to the founding. In fact, before the founding, as he discussed to some extent during the Articles of Confederation, came up in many, many occasions throughout American history. Some of them involving very, very politically sensitive and explosive subjects. The most recent example before Missouri versus Holland went to the Supreme Court occurred in the early part of the 20th century when Teddy Roosevelt was president and Root was Secretary of State, and involved a post-Plessy versus Ferguson issue in San Francisco, and which led to a really very contentious national dispute. The San Francisco School Board decided that it didn't, after Plessy was decided that it didn't want Japanese Americans and Japanese residents, actually. The dispute was mostly about the Japanese residents in San Francisco in the schools with the white children. And they decided to make a separate but equal school for the Japanese resident students. But there was a treaty, classical MFN treaty, Friendship and Navigation treaty with Japan, which required national treatment and other protections for Japanese residents in the United States. And Japan complained bitterly to Secretary of State Root and President Roosevelt that this action of putting the resident Japanese students into the separate school violated the treaty. And this led to a very, very serious diplomatic dispute, and it led, as a matter of domestic politics, to Roosevelt actually flying the entire San Francisco school board to Washington, where he browbeat them, I think, for over a week,
to try to get them to agree to rescind this measure and allow the kids back into the normal schools. In the process, a giant dispute, both politically and within the legal academy, erupted over whether or not the treaty was unconstitutional, in that it affected a matter that is separate but equal schools, which was in the exclusive legislative jurisdiction of the states. The book by Tucker that Professor Ramsey referred to was written really with that dispute in mind, not the dispute over Missouri versus Holland, which in fact came later. So the Missouri versus Holland had, however interesting it is from the point of view of the birds and Missouri and the real environmental conservation issues that were at stake, was also taking place within this much wider context. It turns out it was, I think, as Peggy mentioned in her remarks, it was Senator Root who actually suggested the treaty route, something I suppose he had learned during the dispute over with the San Francisco School Board. So let me begin by commenting a little bit on Professor Ramsey's paper. I'm a bit of a bind here because we agree essentially on all points. Really, we agree. You know, we've been over precisely the same territory. We've gone over the same sources, and we've gone over many of the same arguments. And even at a fairly minute level, you know, we appear to agree, which is comforting to me because his concurrence in his reading of those sources with mine gives me more confidence in my own conclusions, especially since, as he said, he starts with a very different set of normative positions than I would. But let me make a couple of points about Professor Ramsey's paper, but I don't want to dwell on for too long. The first is just they're really both methodological, I suppose. The first is purely methodological, which is I'm myself remain perplexed and doubtful about historical textualism as a methodological approach to answering constitutional questions. To the extent that the emphasis is on a core kind of textualist theory, I'm doubtful that it, in many cases, in many difficult cases, will actually offer a persuasive solution to difficult constitutional questions. Although, ironically, the Missouri versus Holland issue may be exactly a case that fits into as an exception. But in fact, Professor Ramsey's methodology allows him to take into account a lot of history, at least early history during the Articles of Confederation, history post-dating the adoption of the Constitution for a certain period of time. He has a complicated story, which he didn't really try to bring out in his remarks, but are in his paper and he's written about elsewhere, to explain how that history can be utilized in helping to interpret the text. I don't know myself whether or not it's possible, well, one consequence of allowing in the history in this way is that it tends to make it harder to tell the difference between more standard originalist approaches and the historical textualist approach, which he advocates and utilizes. I'm wondering, you know, I guess my own sense is that probably the distinctions, to the extent they could actually be justified on some normative theory, which I'm not sure about, in any event, as a practical matter, are just too complicated, too nuanced to actually make much practical difference. As an example of the problems with textualism, which I think appear in some ways in his paper, but not on the issue that the paper is directly addressing, but on some of the side issues which come up along the way. Just to give an example, Professor Ramsey argues consistently with the Supreme Court's decision in Reed versus Covert that treaties are subject to constitutional prohibitions like those found in the Bill of Rights or elsewhere in the Constitution, accepts that proposition, as do I. But he acknowledges that the Supremacy Clause makes only those laws, quote, made in pursuance of the Constitution, supreme law of the land, but makes all treaties made under the authority of the United States to be supreme law of the land. Now, that difference in language has been commented on many times throughout American history, including by Justice Holmes in Missouri versus Holland. And it certainly led some to think that the in pursuance of the Constitution with respect to laws suggests that Congress's laws are subject to the prohibitions of the Bill of Rights and so on. But the treaties only need to be made under the authority of the United States, which means in accordance with the treaty clause, that is to say, given the advice and consent of 2/3 of the Senate. And on that reading, other constitutional prohibitions wouldn't apply at all to the treaty clause.
Now, that's even a normatively, not only is that a textually plausible reading, I think, it's also normatively plausible as an interpretation of the founding, because the founding, the United States was a small state at that time, a fledgling new country surrounded by great imperial powers. Was certainly within the contemplation of the founding generations that in the event of a lost war, that a more powerful nation might insist on pain of conquest and dissolution, that the United States agree to treaty commitments that might be inconsistent with parts of the Constitution, meaning that which could lead to the inference that the founders didn't think it was advisable to subject the Constitution to the treaty power to other constitutional limitations. My point only is that I agree with Professor Ramsey in his conclusion, and Reed versus Covert on this point, but I don't think the text actually will get us there. Now, let me turn to a second point, which is also in a sense methodological, which is that Professor Ramsey in his remarks doesn't address any of the normative issues with respect to the Missouri versus Holland questions. Others in their papers or in the remarks on the panel have addressed those issues to some extent. And there's what I would have said was a kind of hint of regret about the conclusion he reaches that one feels when one's reading his paper, but he was more explicit in his remarks about that regret here. So I think it's unfortunate that the normative question is so submerged here, because I actually believe, as I've written about quite extensively elsewhere, that the normative case in favor of Missouri versus Holland is really overwhelmingly powerful. I don't have time, obviously, to get into these issues here, but I wanted to just bring out one point, which I think is quite important, and it's a point that I think is not widely understood. So now the argument, let me just put it on the table. The argument against Missouri invariably makes what I take to be a crucial error at the outset. It assumes that treaty making is another form of lawmaking, and therefore the exercise of the treaty power should be viewed through the same lens as exercise of the lawmaking powers. So this gives us the anomaly that the Constitution carefully guards against legislative encroachments on the states by limiting Congress's powers to those enumerated in Article 1, but then turns around and wholly eviscerates those limits by permitting the President and the Senate by treaty to regulate the very areas so carefully preserved from congressional interference. This is a point that Professor Rosenkranz made, and which St. Tucker made in the long quote that Professor Ramsey read. Now, I think it's a mistake to conflate the nature and purposes of treaty making and legislation. Legislation at its core is the power to determine the best rule to impose on those subject to the jurisdiction of the state. The regulation adopted is designed to advance the general welfare and other local concerns. Now, for purposes of legislation in a federal system, we divide the subjects of legislation between the national and the state governments, depending upon which government we think can more effectively and justly regulate with respect to the particular subject matter at hand. The purpose of treaty making is not to impose the best rule on those subject to the state's jurisdiction. Rather, it's to obtain concessions from another sovereign, which is not subject to the jurisdiction of the first state, about how the latter will exercise its legislative powers. The purpose of the treaty is to restrict by contract the other state's legislative power in order to advance the national interests of one's own state. Now, it's true that this ordinarily requires the state to make reciprocal concessions, but those concessions, which will take the form of laws, are not the purpose of the treaty, but the cost which must be paid in order to obtain beneficial concessions. The result is that whether to enter into a treaty on a particular subject is an entirely different question from whether and how to regulate that subject by law in the absence of treaty. It's perfectly plausible, extremely likely, that the level of government most effective at regulating the subject matter, when it's only a matter of legislation, will be different from the level of government most effective in dealing with subject matter when international negotiations are involved. And the purpose is to use bargaining strength to achieve the most advantageous agreement, as well as to balance the national interest in the concessions offered by a foreign state against the cost imposed by reciprocal promises. Now, that is not to argue that there ought to be no limits on the subject matter of treaties. It's just to underscore that there's little or no reason ex ante to think that the division of power over legislation should be the same as the division of power over treaty making. Indeed, prima facie, it seems more plausible to believe that the bargaining advantages accruing to all that are obtained by centralizing treaty power in the national government, combined with the danger that states acting in the international realm will impose substantial externalities on their sister states, make it sensible to grant the whole treaty power to the national government. And we shouldn't be surprised, therefore, that that's precisely what the founders did in the Constitution. All right. Now, let me turn briefly to the papers presented by Professors Vazquez and Swaine, which deal with Professor Rosenkranz's thesis on what we refer to as the second issue in Missouri versus Holland about the necessary and proper clause. Now, in my own view is, with all due respect, that Professors Vazquez and Swaine have been too gentle in their critiques of Professor Rosenkranz's thesis. I think there are many technical problems with various of the argument. The argument is principally a technical, legal, textual argument. I'm just going to give one example, an argument which Professor Rosenkranz spends about 10 pages in his piece developing, which expresses a concern about that to interpret the necessary and proper clause to allow Congress to implement treaties over which Congress has otherwise has no legislative power would mean that a statute passed on one day after a treaty is ratified would be perfectly constitutional, but that at a later time, when the treaty is terminated, would become unconstitutional, even though Congress had done nothing in the interim. The statute's constitutional on day one, and then suddenly it's unconstitutional. This, for Professor Rosenkranz, poses a serious dilemma for the argument accepted by Justice Holmes in Missouri. An argument, by the way, which had been accepted by the Supreme Court on other occasions, which might explain why Justice Holmes thought it was an uncontroversial proposition. Of course, it's doubtful that any such statute would be actually deemed unconstitutional, because it would almost certainly be viewed purely as a matter of legislative intent, as dependent on the treaty. It was passed to implement the treaty. When the treaty falls, so too falls the legislation. So there really won't be a constitutional question. It's merely hypothetical or maybe even non-existent. But more importantly, there are many examples of statutes being constitutional when passed, but becoming unconstitutional at a later point. Consider the war power as the most obvious example. The existence of war gives Congress many powers that it can exercise that it couldn't exercise in time of peace. Rent control is a classic example. There are many decisions in the Supreme Court about rent control ordinances adopted during war and how long they can last after the war until they become unconstitutional. But when the war is over and the emergency conditions which gave rise to the need for rent control in wartime conditions are finally resolved, the statute, if not repealed, becomes unconstitutional. That's clear, and there are many other examples. So the problem is not a problem of that's peculiar to it's a problem at all to the treaty clause. Now, let me just offer another perspective on Professor Rosenkranz's thesis, which I think is not explored by Professors Vazquez and Swaine. Now, the underlying systemic logic of Professor Rosenkranz's position is quite, I think, difficult to understand from a constitutional design perspective. Although he spends a lot of time taking issue with the possible drastic consequences of Missouri's central holding, he concedes that that holding is correct. Instead, he's seeking a more indirect way of dealing with his impact. And his solution is to permit the treaty makers to make treaties on subjects that don't fall within Congress's enumerated powers, but to insist if those treaties are to be implemented as federal law, that it must be done by the President and Senate at the time of ratification through self-execution. If they don't insist on self-execution, then implementation is necessarily left to the states. Now, why, from a states' rights perspective, it's preferable to increase the incentives of the President and Senate to preempt state law outright and make that preemption judicially enforceable against the states is quite unclear. Existing law permits the President and Senate to leave the question of implementation to Congress, which can wait to see if preemptive federal law really proves necessary, can monitor how the treaty is interpreted internationally to ensure that too broad an interpretation isn't imposed on the states by the courts, can monitor whether other states are complying with their reciprocal commitments, can decide how far to comply in the face of domestic controversy, and so on. Now, if it's difficult to understand why Professor Rosenkranz's view is sensible from the perspective of constitutional design, or rather a forward-looking perspective, it's easy to see its attraction if we view the impact of this approach on already existing treaties or take a backward-looking perspective. It's well known that the treaties most likely to touch on subjects within exclusive legislative jurisdiction of the states are human rights treaties. These are also the most politically controversial treaties in this respect. Now, when ratified by the United States, these treaties were famously all declared to be non-self-executing. The consequence of embracing Professor Rosenkranz's view for existing treaties then is quite consequential. We have no, it would mean that the provisions of those treaties affected by Missouri are neither, it would mean that the provisions of those treaties affected by Missouri are neither self-executing, nor can they in the future be implemented by Congress no matter what. We have no constitutional procedure for making a non-self-executing treaty into a self-executing treaty. Unwittingly, therefore, the President and the Senate, when they made the choice to make those treaties non-self-executing, they effectively made them unenforceable no matter how obstreperous the states choose to be, and no matter what foreign policy consequences ensue from the violations. Now that's quite a consequential a fact about adopting this view, not in a forward-looking sense, but in a backward-looking sense. Now, one might wonder whether this approach would be as attractive if the default rule was the opposite from what I've been assuming, and I think Professor Rosenkranz may assume as well, although I'm not sure. Now, say, for example, that the Supreme Court decided to adopt the Rosenkranz regime, but in so ruling also held that for existing non-self-executing treaties like human rights treaties, the presumption would be that since the President and Senate were unaware that implementation would be beyond Congress's powers, that the relevant provisions should be considered self-executing. Perhaps such a rule would be justified on the thought that Congress, under the Last in Time rule, could supersede the treaty obligations that had become self-executing if it wanted to, but could not, conversely, execute the provisions in the future if they were deemed non-self-executing. In other words, in adopting, if the Supreme Court were to adopt the Rosenkranz view, it might thereby choose to make all existing human rights treaties, at least with their respective provisions dealing with matters within the exclusive jurisdiction of the states, self-executing, and then allow Congress in the future to decide whether or not it wanted to supersede those through the passage of legislation. All right, well, I'm going to stop there because I think I've gone over my time. Thank you.
Well, I think we should I think we should give the presenters a couple minutes to respond, and perhaps also think a couple minutes. If one
I will. I want to thank all the panelists and commentators for their excellent remarks. I want to, perhaps unsurprisingly, focus on Nick's criticisms of my criticisms of his argument. I think it's a little premature to declare a Georgetown position on Missouri versus Holland. We do agree that Missouri versus Holland does, in the end, need to be altered, but my alteration is far less significant than his. It's the difference between our approaches, I think, is the difference between addressing the problem with a scalpel as opposed to a sledgehammer. I want to say a little bit about Nick's textualist analysis, because I didn't do that in my initial remarks. I think unlike David Golove, I don't think that textualist analysis is always misguided. I've engaged in it myself. But I think that focusing closely on the text of the necessary and proper clause to solve this issue is inappropriate. And that's because the problem arises because of a doctrine that exists and that Nick accepts, which is itself in substantial tension with the constitutional text. As Nick recognizes, the framers in drafting the Constitution understood self-execution to be the paradigm, and I think all of the panelists seem to agree on this. Mike Ramsey, in his book, I think, takes a similar position. In fact, being an uncompromising textualist, Mike Ramsey concludes, therefore, that non-self-executing treaties are unconstitutional. Nick does not do that. Nick accepts non-self-execution, yet it's a doctrine that is itself in substantial tension with the text. And so it seems to me that it's odd to then, the issue that he discusses arises only because there are such things as self-executing treaties. And so it's odd to address a problem that exists only because of this doctrine, which is itself a departure from the text, by focusing closely on the text. I mean, the doctrine of non-self-execution wouldn't survive the Rosenkranzian razor, and so why should we employ the Rosenkranzian razor to addressing the problem that exists because of the doctrine? Focusing closely on the text of the necessary and proper clause to answer this question produces, as I indicated in my article, some strange results. If in fact Congress, if the treaty makers enter into a non-self-executing treaty, and if Nick's position is correct, the Congress doesn't have the power to implement it if it falls outside of Article 1, Section 8. Yet, such a treaty is clearly the supreme law of the land. If so, then doesn't the President have the power, or the Congress have the power, to call forth the militia to execute it directly, thus dispensing with the need for an implementing statute? If that's the case, then that seems to be a result that's even more, that infringes even more on federalism values. Beyond that, it seems that one would reach the conclusion that Congress does have the power to implement a non-self-executing treaty without regard to the necessary and proper clause, because a treaty, a non-self-executing treaty imposes international obligations, and as I suggest in the paper, one of the principal obligations under the law of nations is pacta sunt servanda, comply with your treaty commitments. If that's the case, then why doesn't Congress have the power to implement the treaty pursuant to its power to define and punish violations of the law of nations? So, again, a close text, applying the Rosenkranzian razor to address this problem seems anachronistic and inappropriate. And if one did apply it, did approach this issue through close reading of the text, I think one would reach the absurd results that I suggest, and you wouldn't even need to rely on the necessary and proper clause to uphold a statute implementing a non-self-executing treaty.
Let me try to be very brief, especially since I'm in a great strategic position. I went into this conference thinking that about ducks, and now I'm thinking about vultures. I mean, the carnage that's been created between the commentators, if nothing else, suggests that I'm really in the position of surveying the battlefield afterwards, and I'm in my own camouflage, given that I'm sort of in the middle of the issues here. Let me try to pose what I hope is a linking theme between the two topics here, and I may be wrong about this, but Mike, one question I had in relation to your paper is the procedural emphasis that emerges at the end of the day is on the two-thirds power of the Senate as a check, as a surrogate for any kind of subject matter limitations, or a sufficient explanation as to what the framers might have been thinking in unleashing this treaty power. And you focus on that rather than two other characteristics, the indispensable role of the President in treaties as opposed to in legislation, and the second is the presence of a treaty partner. That is not obviously necessary for legislation. The reason I allude to that is because the elephant in the room is congressional executive agreements, right? Which involves those other two characteristics, but not the two-thirds presence of the Senate. The link, I think, to the implementing question is this. If we believe, and I read, Nick, I read you to be agreeing with this proposition that there isn't necessarily any subject matter limitations on the treaty power. If we think that procedurally the presence of the Senate is a sufficient explanation as to why the framers would have permitted such potential inroads into the subject matter provinces of the states, why wouldn't we regard that as equally managing the problem of unlimited implementing power? Why could not, in other words, the Senate, in making a treaty, adequately represent the interests of the states as to any shadow that's cast over implementation, by checking and entering only into those treaties that provided a well-defined and narrow power to Congress to implement, including, among other things, through resolutions that instructed the treaty makers as to the kind of treaties that they would enter into. In my view, this is the kind of thing that the necessary and proper clause contemplates. It implies the ability to carry out powers that are vested anywhere in the national government in this vague language that I think is inconsistent with what now is happily being dubbed the Rosenkranzian razor. And it leads to me at the end a narrow question at the end of the day, and that is, what do we do with this power to enter into self-executing treaties if there are some kind of treaties that can never be self-executing, such as those that are constitutionally disabled from being so? Anyway, that's a minor point.
Let me just say three real quick things in response to David Golove's very useful comments. First of all, to clarify, as he did later, I'm not arguing that there are no limits on the treaty power. I simply argue that there are no limits on the treaty power commensurate with the Article 1, Section 8 limits on Congress. I do think that there are at least two important limits on treaty power. First of all, it must actually be exercised through a treaty, and that is a real, actual good faith treaty and not a sham. And second of all, I think that the treaty power is subject to the limitations that the Constitution places on the federal government elsewhere in the document, including the individual rights provisions in the Bill of Rights, as the Supreme Court held in Reed v. Covert, and also any federalism limitations that may appear elsewhere in the document, for example, the 11th Amendment, and also, to the extent one believes in such things, the anti-commandeering line of jurisprudence from the Supreme Court, which doesn't rest on Article 1, Section 8. So I do think there are some limits, but there are not the kind of limits that the people who like limits would like to see. The second point is, picking up on the Reed versus Covert point, I think that the question of whether treaties are subject to other constitutional limitations, that is what the authority of the United States means, as Professor Golove rightly frames the question, is one that can be answered from historical textualist materials, but it illustrates the importance of the historical adjective in the methodology. I agree that simply looking at the face of the text, it may not be entirely clear what the authority of the United States means. But I think that when you look at the history, it becomes more clear that by authority, they meant not simply procedural authority as reflected in Article 2, Section 2, but also things that the United States was permitted to do. And they linked it in commentary, and the framers, especially Alexander Hamilton, made this analysis quite overtly. They linked it to the idea of ultra vires, which was an important concept in 18th century corporate law, that you had certain subject matter, not just procedural, but subject matter as well as procedural, restraints on what you could do as an entity, whether you were a corporation or a limited government, and that things done beyond that limit were not within your authority. And the history, I think, makes that clear, what might not be clear from the text. And let me say quickly, parenthetically, and I hope he doesn't regard this sort of as just a passing elbow, that with respect to Professor Rosenkranz's view, which I've remained somewhat agnostic on, before I would be fully convinced in what I regard as largely a textualist analysis, I would like to see some history supporting it with either some linguistic context or at least some sort of conventional originalist sources, and at least that hasn't been discussed in this venue. And then just the last point I'd like to say is to pick up on the normative question that Professor Golove raised at the end, and I think that is important, and he's right to detect a twinge of regret in my writing. And I think that if we're looking for a place that he and I can disagree, because we do agree on a lot of things, it's on this point. I do think that the normative weighs heavily against Missouri versus Holland, particularly in the modern era. And for me, the critical point is the 17th Amendment, because while I think that the framers' design was quite sensible, as long as the state was conceived of, as long as the Senate was conceived of as a representation of the states, the procedural protections that provided were certainly strong enough to reassure the framers, and I think strong enough to reassure me. After the 17th Amendment, the Senate no longer represents the states. In fact, the Senate is a competitor to the states for power. And so the Article 1, Section 3 protection doesn't exist anymore. So I have a good bit of sympathy for people like Professor Bradley, who are concerned about this. But I think that the attempts to go back in paper over the 17th Amendment by reinterpreting the original meaning of the Constitution, which is somewhat of what I regard Professor Lawson and Seidman engaged in, simply don't work because the 17th Amendment did radically change things. And so normatively, I am out of sympathy with Missouri versus Holland, but I think it's important in trying to decide what the Constitution originally meant to really consciously separate ourselves from the normative, and that's why my paper explicitly tries to do that.
I want to respond briefly. I think we're going to issue about starting rate about 5 to 11.
Okay.
That's a little built in.
All right. So here I thought I'd offered a strategic truce to Mike Ramsey right at the outset, and now at the reply phase I get the passing elbow, so I am truly beset on all sides today, but that's all right. I take it as a compliment. I think it's all, all publicity is good publicity. So let me just respond to a couple of things that were just said. First, Carlos's point about the Law of Nations clause, I think, is very interesting, and I'm going to admit that I'm not an expert in the Law of Nations clause. Generally, I believe it's thought to concern customary international law rather than treaties, but I think it is a valuable issue for future study. But there is a fascinating footnote in Carlos's article on this point, in which he seems to suggest that the necessary and proper clause is not the right home for this. The necessary and proper clause actually doesn't work as to this. And I'd like to hear Carlos's thoughts on that. If he does, then that's a third revolutionary point on which we agree. The necessary and proper clause, contra Justice Holmes, does not get you there, does not give Congress power to pass legislation pursuant to treaty that it otherwise could not pass. So, Carlos, if we agree on that, I'll be delighted. Let's hear more about that. And then, other than the Law of Nations clause point, Carlos's big point is that we should despair, really, of using textualism in this context, because non-self-executing treaties themselves are somehow in tension with textualism. What he means is, on the text of the supremacy clause, it looks like all treaties are really meant to be self-executing. As Carlos said, he and I agree that self-executing treaties were the paradigm. I'm not so sure, though, that non-self-executing treaties are in such tension with a textualist reading of the supremacy clause. I think the way that a non-self-executing, the way to think about non-self-executing treaties, if you're a textualist, is simply that they are supreme law of the land, to the extent that they are, by their terms, supreme law of the land, to the extent that the treaty itself is purporting to be law. But if the treaty is purporting just to be a promise that we will implement legislation in the future, there's nothing in the supremacy clause that would forbid that. To see the point most clearly, think about a non-binding congressional resolution, right? If both houses of Congress vote on a statute and the president signs it, that makes it a law, and it is supreme law of the land under the supremacy clause, but nevertheless, it might not do anything. It might just say, somebody should do something. It might just be precatory, as congressional resolutions generally are. Nobody thinks that that's problematic under the supremacy clause. It's just, by their terms, they're not domestic laws. There's no reason to think that a treaty can't work the same way. So I'm not as convinced that we should give up on textualism from the get-go, and therefore I do think we need to train a careful lens on the necessary and proper clause. I'm delighted to hear that when Carlos does that, he is not so convinced that it justifies Missouri v. Holland. Now, just one other point. This is a big structural point. So David Golove thinks it's crazy that a self-executing, so my position is that a self-executing treaty can go beyond the enumerated powers of Congress. And that it will be then supreme law of the land under the Supremacy Clause. But a non-self-executing treaty doesn't then give Congress power to implement it. David Golove says, well, that's crazy because you're allowing you're allowing the route which is more destructive of federalism, more intrusive in states. That's the self-executing treaty, and yet you're not allowing the less disruptive route, the non-self-executing route. I want to say that's not the right way to think about this. A self-executing treaty is a one-shot. It is one shot. So the treaty makers enter into it. It becomes domestic law of the land. It's like a statute. It's like a statute. That puts everyone on clear notice as to what is going on. So if such a thing is going to preempt a bunch of state law, it's very easy for governors and state legislatures to understand, and senators to understand what's happening ex ante and to say, we don't like this treaty because it will preempt all kinds of Missouri law that we like and care about. That's an easy and clear thing. A non-self-executing treaty doesn't work this way. So a non-self-executing treaty can be very vague and say, we promise to pass legislation that's in the best interest of children, or families, or ducks, or whatever you want to say. And here's the discussion that can happen. The governor of Missouri calls up his senator and says, don't enter into this, don't vote for this treaty because it's going to preempt all sorts of state law. The senator says, no. It's going to have no effect on state law. Don't you worry. It's non-self-executing. We're totally in compliance with it already. This treaty basically does nothing except to impose some obligations on our treaty partners. Don't worry. Then, 10 or 20 or 30 years later, while this treaty is on the books, Congress can discover it. It sits around. It lies around like a loaded gun, waiting for Congress to discover it and pick it up and say, you know what, that treaty, that non-self-executing treaty, actually gives us power to do stuff we wouldn't otherwise have power to do, like regulate guns near schools, things like this. So I want to say these are quite different things, and the non-self-executing route is going to be much more attractive to treaty makers and to senators in particular, because it increases their power. And so just to put that point as responsive to Ed Swaine's point, this is why we're not satisfied with the 2/3 requirements. Because what's happening here structurally is you're giving people the power to vote on increases in their own power. You're saying to senators, do you think that you would like to have some more power tomorrow, yes or no? Say, well, we'll have a 2/3 requirement on that. It's just not satisfying. 3/4, 90%, 99%. Yes, I think I should have some more power. That's the concern. And let's see. Maybe that's all that I need to say. Can we take questions or?
Well, Mr. Carlos, to follow up on the last point that you mentioned, sort of about the political safeguards question. The two related ways of answering. The first is whether you describe yourself as not concerned about the bad faith possibility for that reason. And I wonder to what extent Holland represents the bad faith scenario, and in fact it does, and is there a story there, to sort of some reconciliation. Second piece of it was, with your concern about the debate provision, I want to have the same, in essence, question there. Why do you believe that it's effective with the ordinary, the bad faith case? Why do you not have confidence there? Now there, it's not a 2/3 majority, but it's a double majority in the two houses, and I just wonder whether there too we wouldn't expect to get, if you believe this political safeguard premise, I guess I would wonder whether you won't get it with your debate provisions as well, and then you don't have your dilemma.
And so, just to clarify the last question, is your suggestion that the exception for vague provisions is not necessary because you have the political? Well, I mean, as to that, I'm not really a believer in the political safeguards on legislation. I'm not an adherent of the Wexler view. I think the political safeguards with respect to treaties, though, are higher. And I am convinced that those safeguards are the ones that the frame was intended to protect us against unwise treaties. And so perhaps my answer to the second point is just a simple one, that I don't think it's appropriate to rely on the political safeguards of federalism to protect us against statutes that go beyond Article 1, Section 8.
Is that just simply because of the supermajority requirement, or there's something structurally different going on in the Vague case versus the case of the Vague provision versus the treaty? It is basically the supermajority requirement that I think it's just hard to get 2/3 on anything. Now that raises the hard question. Was your first question, which was Missouri itself a bad faith case? And I don't know enough about the history of it to make a judgment. If so, then perhaps some vague treaties under some some bad faith treaties under certain circumstances can get through. I think the sham exception that both David Golove and Mike Ramsey accept perhaps is necessary to take care of that. But I'm persuaded that that's unlikely to happen. I do agree with Nick that vague and aspirational treaties, with respect to vague and aspirational treaties, the 2/3 requirement is going to be less effective, precisely for the reasons he gives. In fact, if all of Nick's final points focused on vague and aspirational treaties, that was his focus as well on the textual point, how can non-self-executing treaties be consistent with the constitutional text, the text of the Supremacy Clause. Well, if all we're talking about is vague and aspirational treaties, then we're in even more substantial agreement than we thought at first. But I took his argument to be that even if the treaty is not vague and aspirational, even if it's specific and obligatory, if it goes beyond Article 1, Section 8, Congress lacks the power to enforce it.
Carlos, I'd just like to ask you a question. This vague and aspirational, to me, these are two very different ideas. So aspirational, I understand to mean prefatory, right? Like we should do X, as against we shall do X.
Right.
So I understand that, but vague is not necessarily aspirational. Vague could be mandatory. You must do X, but X is vague. And I'm wondering, is there a distinction here? Are you wanting to cover both categories? Maybe to ask the question more concretely, imagine a treaty which is not aspirational. It says shall. And it's not that vague in that it can be enforced in two ways. So it can be complied with in two ways. You can comply either by doing X or Y. X is within the enumerated powers of Congress, and Y is not. Do you believe that Congress can opt for Y in that case?
Well, that's an excellent question, and you put your finger on a point that, with respect to my article, that is undeniable, which is that I haven't fleshed out the distinction between vague and aspirational on the one hand and specific and obligatory on the other, and I think that is a hard line. It won't be an easy line to draw in many cases. I think that might be an issue that I will flesh out again with the help of the editors of the Missouri Law Review. But the way I put it in my piece is that Missouri versus Holland would not apply with respect to treaties that can be complied with by doing nothing. In the sense that if we leave it to the states and the states do nothing, there is no identifiable violation. So in the case of your hypothetical, treaty requires one of two things, one of which is within Article 1, Section 8, and the other is not. That is something that requires some conduct on the part of the United States in order to comply. And so on the standard, insofar as I've articulated it, it wouldn't fall within my exception to Missouri versus Holland. But the interesting question is the one that you raised. Would the president be limited to the one that falls within Article 1, Section 8? I'll have to think about that some more, but I think I don't have an initial problem with saying yes.
Just actually one small point to follow up and then actually a question. One thing I also think you might want to think about this vague and preparatory sort of standard is things like a future arbitration, which the U.S. had to do with the U.K. over whether or not whether it's promising to make best efforts with a legal obligation. Arbitration saying yes, actually, you can. That is a standard that can be evaluated legally. And so I think that there is some question of how that cuts. If you're going to say vague or aspirational language, how do you deal with the international law precedents out there about actually having enforcement? I guess, but my larger question was one. First of all, my bias is I love Missouri because it's one of my favorite cases. But I'm also surprised that the whole dialogue, to me, seemed largely, again, maybe that's the point, doctrinal, without any real consideration of the actual practice. And my own particular bias is that once, in some sense, I wonder how much this is tilting at windmills. I mean, if you actually look at the practice, and here I'm thinking specifically of the treaty maker, that is the President and Senate's own exercise of the treaty power, it seems to me that Missouri v. Holland, while still on the books, is not being utilized. That the fear which Professor Bradley and Rosenkranz preach against is not actually a fear that has been realized. And in fact, the executive has taken demonstrable steps to limit the treaty power when federalism issues are raised by negotiating federalism clauses, by putting forward federalism reservations, by putting forward federalism understandings where they specifically said, we're joining this treaty and we can comply with existing law, and this treaty should not be read to be the basis for some additional future legislation. And I guess I'm just wondering how that fact that you have, and this is, I actually argue, scholars goes back, that there's a tit for tat over the history and attention, but if you can go all the way back to this consistent theme with the executive is self-enforcing or self-restraining in some sense, the treaty power, cognizant of the federal structure, how that affects this dialogue. And then one last point is also the fact that and this may be just a debate about what non-self-executing means, is it's always been my understanding that the executive branch, the President, does not join a treaty, even a non-self-executing treaty, unless he believes that the United States is in compliance with that treaty and ratification. In other words, we don't join unexecuted treaties. We just look and say existing law meets the treaty's obligations, or we get the new legislation and wait for it before we join. Now, that doesn't eliminate the problem of, well, maybe you could have additional legislation that would help comply further, but I think that the fact that you have to think about it, if you think about it that way in terms of the executive, the President doesn't join treaties in which they're going to be immediately in non-compliance, how that affects the analysis.
I'm not sure if that was for me, but I'll answer it. First of all, I plead guilty to being purely doctrinal in my analysis. That is my focus in this paper. I completely agree that this may be tilting at windmills insofar as there may not be much political will to exercise the power that the federal government has under Missouri v. Holland. It may also be not a very significant issue in light of the fact that the limits under Article 1, Section 8 are so broad. This is another respect in which this analysis may apply to a very small percentage of cases. Professors Bradley and Rosenkranz were writing right after Lopez and Morrison. Now we have Rage, which may suggest that those limits aren't, the limits in those prior cases aren't that significant in the first place.
Just briefly on this point, I think one can assume that the positions that the United States takes through adopting a reservation or trying to seek a federalism clause are constitutionally informed. And so they may be representing the view that Missouri versus Holland is no longer good law, right? Or that they don't, or that they have independently formed a view of the Constitution that is different. And so I think the doctrinal debates still resonate, and even because they speak to actors who themselves wish to take constitutional actions, in some cases wish to exploit to the hilt what the Constitution permits them, in other cases wish to differ, in other cases admittedly don't care. But I do think it remains pertinent in that regard.
Sorry. Let's get Ellie's question. I think the issue that Dr. raised is a little bit more further the roundtable. I actually, there was something along those lines of the question. So, yeah, Ellie's question is brief response, and I think we do have to take break. There's lots of time for questions.
I'm trying to keep this brief, and this actually bears something that Carlos Vazquez just mentioned, which is the impact of Gonzalez versus Rayshon. If I understand Nick's article correctly, to some degree motivated by the resurgence of the new federalism with Lopez and Morris, who were taught for the first time in 60 years, maybe there are some things that Congress can't do under its enumerated powers in Article 1, and only if there are things that Congress can't do under Article 1 does it actually become a live issue of, well, can it add some other things under treaty power? But since Gonzalez versus Race, which is, as I've argued earlier in mine, makes almost anything subject to Congress's regulatory reach, I wonder if in some sense this debate, while I agree extremely important from a trial point of view, has not also been someone that's superseded from a real-world point of view, related to that is the real-world phenomenon of executive congressional agreements, which, to the extent that they're not treaties in the constitutional sense of the term, are not subject to these limitations. Most major international agreements today do in fact take that form. Now, it's possible that Nick will argue, well, that's also unconstitutional, and that in some respects be actually a much more radical attack on existing practice and just in this article, but nonetheless, you need these two combined realities, race and executive congressional agreements. My question is, what is sort of the practical significance of your disagreement in light of these two things, other than perhaps, well, maybe the Supreme Court will reverse race in the future. I certainly hope that it will, but the prospects don't seem that great, at least for the next 10 or 20 years or even more.
With 30 seconds remaining, I think I will not take on congressional executive agreements and declare them all unconstitutional today, but maybe tomorrow. As to the practical implication, I'll just say a couple of things about it. One is, it's certainly true that this debate is less significant in light of race, right? This debate matters only at the point at which Congress lacks power to do something absent the treaty. If congressional power under the Commerce Clause is infinite, this doesn't matter at all. It's virtually infinite. It matters only in that little margin. I would say that even in that little margin, though, scholars latch right onto this. So the minute that Lopez appears at the Supreme Court, the minute Morrison appears at the Supreme Court, you see briefs where scholars are filing briefs that say, even if this is beyond Congress's power, it's fine under the International Convention on Civil and Political Rights, see Missouri v. Holland. In Morrison, scholars are filing briefs saying, even if this is not okay under the enumerated powers, it's still okay, see Missouri v. Holland. So the minute you have a suggestion that there's anything Congress cannot do under Article 1, Section 8, you will immediately see the Academy turning to Missouri v. Holland, and it will matter to that extent, however big that extent is.
Okay, Carlos has indicated this, 30 seconds.
Yeah, just a minor comment on the congressional executive agreement point. I think my position seems to be the opposite of Ilya's, because I view, in my view, Missouri v. Holland doesn't apply to congressional executive agreements, and such agreements therefore must fall within Article 1, Section 8, and that's because the structural protection of 2/3 of the Senate does not is inapplicable there.
Okay, thank you.